You can refer in your handout to page 39 through 44. One of the things we want to make sure that's clear is the difference between administrative segregation and disciplinary segregation. We've got two different kinds of lockdown, and they've got really two different requirements for each one of them. You need your jailers to understand the difference because they're going to be the people who are moving someone from one place to another, from general pop into administrative segregation and doing that sort of thing, or maybe moving them to a disciplinary segregation. And I also recognize that you may have, your facility may only have one area that houses both ADSEG and disciplinary segregation inmates, but how you handle those inmates is different. You need to make sure to recognize that difference. So, administrative segregation is really, we're talking about order and security lockdown. If you, we're on page 44, or 40, excuse me, and 41. This is when you're transferring an inmate because of an order and security issue. Maybe they are, you feel like they are in danger. Maybe they feel like they are in danger. Perhaps you don't have anywhere else you can locate them because of the nature of their charges. Or perhaps you don't have anywhere else you can locate them because of something such as their sexual orientation. Or perhaps they may be a transgender inmate, someone of that nature. Those people are people you are housing administratively segregated from other groups because you have that affirmative duty to protect them. If you can assure their safety to the highest possible degree in general population, then that's what administrative segregation is. A lot of times we're talking about issues where you may not be certain of their ability to get along with other inmates. And that's different from disciplinary. We're talking about someone who can't be among other ones because he or she is dangerous. The difference, though, is you're going to put them in administrative segregation. They may be locked down like the others for most of the day and only out for that hour a day, but they still maintain the privileges that other people in general population do. For instance, visitation. They could still have visitation according to the rules of your jail. Correspondence, receiving mail, maybe if you have commissary, those sorts of things, those sorts of privileges that are available to folks in general population should still be available to your people in administrative segregation. It may be limited because, for instance, you can't provide them visitation at a time when other people might be in the visitation area and you've got to protect them from those other people. So it may not be that everybody in general pop gets to watch TV and people in ADSEG can't watch TV because there's not a TV in their cell. That's one thing that we can help you deal with. But generally, those just privileges are not taken away; those are retained. We can't make it so that being an administrative segregation is the language that the court uses is substantially more onerous than being in general population. We don't want you to use this as an excuse, put them in a hard place, so to speak. If we've got a disciplinary issue, let's deal with the disciplinary issue. It is perfectly legal to segregate based on race in the jail because if you have some indication that there is going to be a problem that falls along racial lines, whether it be, whatever the racial line that you're experiencing may be, then that's fine to do. We don't worry about integration in the jails. We're worried about protection in the jails. It's also fine to segregate, as I mentioned, based on their sexual preference. It's also fine to segregate them based on their mental illness. If you cannot protect them from themselves or others in the general population, then it's fine to segregate them. I know I've had some experiences where an inmate just, he could be in general population for just a few minutes before he was already stirring up other problems and causing other trouble, but not necessarily violating the rules, but just creating a more tense situation, causing more problems. He would get agitated, become dangerous to himself. Administrative segregation is the way to go in a situation like that. If you look on page 41, in the middle of the page, it talks about recommendations for avoiding liability. When we're talking about administrative segregation, we want to, let's see, I think I'm talking faster than my PowerPoint's going. We want to make sure that you don't put someone in administrative segregation and forget about them. So one of the ways that we recommend that you can avoid liability is to make sure and consider sort of both sides of the issue before you put them there or as quickly after you put them there as possible, and understand the reason why they're there. Okay, Mr. Smith, we're going to put you in administrative segregation because our facility is not big enough for us to keep you away from people who are witnesses or co-defendants in your case. So we're going to have to house you here to make sure that we can protect you. And he may not, Mr. Smith may not agree with that, but that's the reason for doing it. And about every, we'd recommend that you do a review of that about every 30 days or so and say, okay, this was the reason we had you in administrative segregation. That reason still exists, so we're going to keep you here for another 30 days. Or, maybe it's changed. Okay, Mr. Smith, your co-defendant got released, so we're going to allow you to go back into general pop now, whatever the case may be. The key is to document it and to know why you're doing what you're doing. Got a question in the back of the room?
Yeah. Is anything covered under medical, such as HIV or AIDS?
What do you mean, is anything, okay, so is segregation based on okay, again, that's a medical judgment, and so my recommendation is that you go back to your medical care provider. Because honestly, as a lawyer, I don't want to make a call as to whether or not someone is contagious. I have all kinds of information floating around in my head from what I've read on the internet, and what may or may not be true. So if you have an inmate who has a potentially contagious disease, I would recommend that you consult with your medical care provider and say, doctor, we need you to make a recommendation as to whether or not this person is contagious to others, or whether or not they need to be kept separate, and that way you have a medical basis for making that medical decision. But I would not have, again, as Mike says, an across-the-board policy. Anyone who comes in who has had a hepatitis C diagnosis is going to be segregated. That's going to be a problem because you may be treating them based on, you may be discriminating against them for no reason really if they're not actually in a contagious stage. So rely on your medical people. Put it all back on them. Okay? Other questions about avoiding liability. Do not continue to use administrative segregation longer than you have to. Don't let this be punishment. Using it over and over as punishment really, is going to impair your ability to use it effectively. Use it. It's real easy to find a reason to put someone in administrative segregation if they need to be there. You just need to be able to identify what that reason is and just stick with it. I always say, know your purpose, know your reason. What are we trying to prevent here, or what are we trying to solve? And that's probably a good reason to go to ADSEG. Okay, privilege deprivation. This is really more talking about disciplinary process, disciplinary segregation. This is when Mike talks about the difference between punishment and discipline, this is really what we're talking about. This is how you discipline effectively in a jail, is by privilege deprivation. By saying, since you can't follow the rules, Mr. Smith, we're going to have to not only put you over here in segregation, but you're not going to be able to get commissary for these 30 days, and you're not going to be able to have visitation for these 30 days. And we're going to really have to limit what you do, and it's not going to be any fun for you. It sounds, maybe a little bit juvenile. I mean, I can remember when I had, a toddler screaming and pulling her hair out, and I'm thinking a timeout chair is going to do nothing for this. But it may not immediately, but over time, that's how we most effectively restore order in the jail, by depriving them of privileges. So, oh, did I lose my page? Sorry about that. All right, well, we'll just stick with them with page 42 where we are there. The difference between ADSEG, really, from a manpower issue, the difference between ADSEG and disciplinary segregation is there is a due process requirement to disciplinary segregation. When we talk about due process, we're talking about the process that you must go through in order to take those privileges away. And I know that it's a lot of times you're dealing with a quickly moving event, things are happening fast, you need to be able to respond quickly and deal with it. Honestly, the courts don't care. What they want to see is, do we have this process in place? So, before you actually put someone in disciplinary segregation, and again, I know that the distinction between the two may be as much as you saying, okay, Mr. Smith, you were in ADSEG and now officially you're in DSEG, but you're not moving anywhere, you're staying in the same place. The only thing you're doing is taking away his privileges, but before you do that, you've got to go through this process. So if you look there at the middle of the page, procedural due process is required. We're distinguishing between two types of due process. One is procedural, meaning the process, the steps you must take to go through that, and the other is substantive, and we'll talk about that one in just a second. The procedural due process that's required is going to be that the inmate has got to be offered a hearing before a neutral officer, an officer who was not involved. That hearing must give them enough, you must have that wait long enough to have that hearing to make sure they have an opportunity to present their side of the story. Okay? Let's talk about the practicalities of that. How do you accomplish that? When something happens, as soon as everything is calmed down and you've got someone, when something happens, the first thing you do to get that person out of there is you take them and say, I'm putting you in ADSEG until we figure this out. You put them in ADSEG and you hold them there for just a little bit until you get all your reports done and figure out what's going on. The next thing you do is you serve them a disciplinary citation, something in writing. We've given you a form here that gives you an idea of how to, what kind of form to do that. Most of you have detainee handbooks or something that may list the rules. You tell that detainee, this is the rule that you violated. And we're going to have a hearing for you no less than, no more than, well, I guess I'm getting it backwards. We're going to wait at least 24 hours, and we're going to give you a hearing. It's going to be in front of somebody else that wasn't involved. And Mr. Detainee, if there's someone that you think is a witness, or that you think that the hearing officer needs to talk to before they make a decision, you write down their names right here. That's your cellie. You tell me who that is. We're going to go back, and then you have your group of officers who could be the hearing officers. They go to those folks and say, Mr. Smith says that you might want to give a statement about what happened in here 2 days ago. Here's your piece of paper. I'll come back later on today and pick that up from you. If they say, I'm not interested, I don't want to give one, you say, okay, thank you very much, and you move on. But ultimately, that inmate needs to be heard on his or her side of the story, and the hearing officer needs to make a decision as to whether or not to place that inmate in, at that point, disciplinary segregation. That decision needs to be made before they're placed in disciplinary segregation. And, you need to give them at least 24 hours to give their side of the story and name witnesses and whatnot. But my recommendation is that you not wait days and days and days. This is not a night and weekend thing where you're having to worry about, I have a certain amount of time. The question is, are you giving them that procedural due process? And they need notice and an opportunity to be heard. So if you give them this written citation, and then you give them an opportunity to come before this neutral hearing officer, then you've given them procedural due process. Since Mike's standing up and walking over here, I'm on. I know he's coming, so.
Y'all look at page 42, if you're not already there. This seems really confusing, I know that. But again, we kind of go back to the home situation. If you got two kids fighting, what do? Well, you separate them. And just imagine that same scenario, except now they're fighting in front of an audience. Most of this showing out is they're showing out in front of friends. Problem is, they're not convicted, so they have a right to be in general population. Believe it or not, that's a right. I'm an unconvicted person. It's part of my freedom of association. But I can lose that right by acting out. If I act out, I've got two problems. Problem number one is I need to restore order. So I jerk them up and I take them over and I put them wherever I want to. Doesn't have to be a particular cell. It's just I take them out of general jail population. And I say, sir, I'm going to have to administratively segregate you. And really what you say is, I'm going to have to segregate you for a little while, let everything calm down. The reason it's called administrative segregation, you're just making an administrative decision to maintain order or to restore order. Okay? So if this is in your home and you've got a kid and it's the first time he's ever done it, you're going to jerk him up and you're going to go say, your administrative segregation is you go in your bedroom and the other guy go in his bedroom. And that may be the end of it. You know, 30 minutes later, come out and let's all start over again. No big deal. Now they have the general run of the house. Okay? But if you decide for whatever reason, you know, they're not going to get it, because I've been down this road before. They're not going to get it by they have to go to their bedroom for 30 minutes, and, you know, we're not supposed to fight with each other. You say, I guess I'm going to have to do more teaching. I got to get their mind right. And what you got to do is you got to convict them of violating the jail rules that say you can't fight in the jail. Procedural due process, you got to have notice, you got to hear both sides of the story, and somebody not involved, a disinterested third party's got to make the decision. You don't have to go to a trial, you don't have to have a judge, all this can be done informally. Okay? What you need to do is say, let me explain what's getting ready to happen here. You know, you keep showing out, I'm sick of it, your fellow inmates are sick of it, I got to do to protect everybody, including you, so I can't seem to get your mind right, so we're going to get your mind right. Bam, here are the rules. You violate this rule right here, and it says that you can go to segregation, isolation. We don't like the isolation word. That sounds punitive. Okay? We're going to put you in disciplinary segregation for 30 days. That's the range of punishment for violating this rule inside the jail. So you think about the jail, it's like a society inside a society. So what you're going to do is you say, in our little society here, you violate the rules of our little society, and we're going to have a trial, find you guilty, and punish you. So we don't use the word punishment, we use the word, we're going to have to discipline you. We're going to have to get your mind right, that's the way I like to say it. So what you do is you say, it's going to take a little while, and in the meantime, I'm not going to let you get in general jail population because I can't trust you to act right. So you cool your jets over here for a little while while we get all our stuff together. And then you go in there and say, you're accused of violating this rule right here, it's 30 days, and here's the way it's going to happen. I want to hear your side of the story. Now, the officer involved shouldn't do this. Go get your shift supervisor. Go find somebody else. Have them come in there and say, hey man, you've been charged with violating rule book so-and-so, and there's up 30 days for this. I don't know whether you did or not. Tell me what happened. Well, I didn't do anything. It wasn't my fault. The other guy jumped on me. All I was doing was defend myself. Say, thank you very much. Anything else you want to tell me? Yeah, this ain't fair anyway. They hate me, and I hate you too. Heck you. He said, well, thank you very much, sir. I really appreciate that. See, he's not agitated because he wasn't involved in the fight. He's not mad at the guy, you know. He's just doing his job. So he said, I'll tell you what, you stay right here. I'm going to go, you got any witnesses? Yeah, I've got this guy and this guy. Okay, I'm going to go talk to them. You go down here and you say, hey man, Joe Blow over there, he's charged with violating this rule right here, and I'm trying to figure out what happened. I'm going to hear everybody's side of the story. You tell me what you saw. Go next guy, you tell me what you saw. Okay? Then you come back to the guy and you say, all right, I've heard everybody's side of the story, and let me tell you what they said, and this is what I think, this is my conclusion. You got anything else you want to tell me? Yeah, I think you're wrong. I think you hate me, F you. And you can say, thank you very much. I'm going to recommend to the so-and-so that they find you guilty and they impose a sentence of violating our rules. You're going to have to spend 30 days in lockdown. I hate that for you. I'll see you later. Okay? See, what you did is you had a little trial inside this little society called jail society, just like you would have done if you were applying the criminal laws on the outside. You with me? Now look, you can run a jail without doing any of this. I don't care if you do this or not. It's probably easier if you don't, quite frankly, because judges love to trip us up on procedural due process. But it's the same thing in criminal court. You think those criminal defense lawyers are winning because their client is innocent? No, they come in and collaterally attack the process. You know, they're questioning everything, trying to find disputing credibility, creating doubt. It's a little game we play in society, but it's the game we have to play because it's the game that separates us from the rest of the world. The rest of the world just comes in and says, the officer told me that you violated the rule and you, sir, are now guilty and you're going to stay in here for 30 days and I'm going to throw away the key. That's the way they do it in Russia. We don't do it that way here. We follow procedural due process. In other words, the government is forced to humble itself to take the time to actually hear the other side of the story. And the only reason we do that is because we were created with a reasonable mind. Even though we don't have to be reasonable, the government only has to be rational. It's making decisions by people who are reasonable because they have a reasonable mind. You're not crazy, you have a reasonable mind. If you have a reasonable mind and you stop and hear both sides of the story, your mind will automatically compute. You can't keep it from computing. And it will draw a conclusion that is reasonable. It may be wrong, but it's reasonable. It's based on the facts. You heard both sides of the story, and then you apply the penalty. If you follow this little form right here, it will save your bacon. And when you get sued, we'll use that as an exhibit. It'll fit on one page. I've got it on one page. And I can send it to you. We can send it to you. Then everything's cool. Because you got one sheet of paper that says, Judge, we know the difference between administrative segregation. I did that temporarily to solve an immediate order security problem. And I only left them in there as long as I thought was necessary for them not to act up again. And then we shifted over to, I found him guilty of violating the rules that he had notice of. We had an impartial person, hear both sides of the story. We made a decision. Man, the judge is going to be applauding you then. Simply because you know the difference between the two. Okay? This is very much like, grounding. Back in the family setting. You pull out grounding when it's like, dang, it's gotten serious enough, I'm going to have to ground you. You don't get to have your car anymore. That's your privilege deprivation. Why? Well, because you can't use your car in an orderly fashion, son. So I'm going to have to get your mind right. I'm going to have to start taking stuff away from you. I'm going to start with, I'm going to take you out of general jail population. I know that's where all your buddies are. Believe it or not, criminals are social. They love socializing. All of us love to socialize. We're built to socialize. Part of how we're hardwired. And it hurts when you don't get to socialize. Okay? And then on top of that, we're going to take away what it is they're abusing. We can't take away what they're not abusing. We have to take away what they are abusing. And if they're in there and they want to go to church, well, guess what? That's a fundamental liberty right, and we're going to let them go to church. Oh, wait a minute. They can't go to church because they can't get along with other people, and that's part of the difficulty. And we asked the preacher, and he said he didn't want to hold a private church service for you, so I'm sorry you don't get to go to church. But we did ask him if he wanted to counsel with you, and he said he would love to do that. Okay? So then we bring him back there, and he talks to him between the bars, whatever. See, get the idea we're running a little society inside of a big society. There's a difference between maintaining order versus having to actually go the extra mile and ground them for a while and take away the toys. Okay? If you use this little form right here, it'll really help you. Does that make sense? This is huge. These judges love to camp out on this. They love to get you in there and grill you and get you confused. And they're not doing it because they don't like you. They're doing it because they want you to get the fact that procedural due process is what separates us from the rest of the world. It is a huge, huge, huge thing. It's really what makes America work. And it's really what gives us our freedom. Because you don't know what your kid's going to be on the other end of that. You just don't know. But you want to make darn sure that whenever you're the guy that the government's pointing its gun at, that you can say, wait a minute, time out. What are the rules I'm supposed to have violated anyway? And number 2 is, when do I get to tell my side of the story? And number 3 is, I don't want somebody that hates me to make the decision. I want to be somebody that doesn't hate me. I want to be somebody that's cool and calm and they understand the way America works, and they're going to go in there and they're going to make a reasonable decision. This is a big deal to us because we spend a lot of time, we waste a lot of time on this issue right here. And what I'm saying is, teach these guys while you're in there. Explain to them. Say, let me tell you exactly what I'm doing, knucklehead. You show out, we're going to take you out of your audience. You keep showing out, we're going to take everything we can take away from you until we get your mind right. And you may have to stay in here the whole time you're in here. That's fine. We don't care. But we prefer that you play well with others. So, that's kind of where we are. Sorry. I apologize all the time for talking too much.
That's all right.
Yes, sir.
Is there a problem with having in-house disciplinary measures as well as filing formal criminal charges?
Not at all. If they violate the laws of our society, that's a separate issue. They assault somebody, they batter somebody, absolutely, you can pursue that. You know, all these are tools. All these are tools. Think about them as tools, okay? And all of them, what you're trying to do is make your life easy. And the way your life's easy is you have an orderly environment to work in, and people don't get hurt. That's what we want. Yes, sir.
It's actually a two-part, so this is about.
That's all right.
The third jail law seminar I've attended this month alone, and one earlier this month, as well as one yesterday, mentioned that inmates that were already in disciplinary barracks were exposing themselves to female staff members. The detention.
Female staff members just have to get used to it.
Well, go ahead. The female staff members sued the county jail and won because they were being discriminated against themselves.
Well, if you allow an environment that, you know, does harass or is a hostile environment on the basis of criteria that you could fix, yeah, there's liability for that. It's back to always or never. You know, if your system is, oh, well, you reported to me, I didn't do anything, well, that's a problem. But if your system is, hey, we tried to rearrange stuff, take a different path, and you know, guess what? You don't have to work here if you don't want to every now and then see somebody expose themselves. But if you're making me, you know, be continually subjected to a bunch of knuckleheads, you know, showing me their junk, that's a problem. Okay? Does that make sense? So all this stuff is like, you know, all lawyer answers are what? It depends.
Maybe.
I'm over to go to lunch.
Okay, let me, really quickly, before we go to lunch, and that is next, and I promise I won't talk long, but I want to point out page 86, grievances. That was one of the topics I was supposed to cover. And, you know, grievances, as I think Mike mentioned it before, grievances may seem like something that they just wear you out with. They're always complaining about something. But let me tell you what, this is a good thing. Because a grievance is, let me see if I can get it here. A grievance process can, if you have a process and they do not follow it, we will ask the court to kick the case completely. And it doesn't happen often in our cases because a lot of our jails don't have the process in place. But the ADC, they have a very specific process, and if the inmate does not complete the process, the courts will kick the case out. So have a process and follow it. Not only is it good for that purpose, but it also creates the documentation that you may not otherwise have. You have what their complaint is, and you can very specifically address it. I was talking to Lieutenant Williams here before, up in Carroll County. They've got a very particular inmate who has a lot of issues. He is of an Orthodox religion. He asks a lot of questions, and it's usually, you're not letting me do this, you're violating my First Amendment right. And Lieutenant Williams has worked real close with me, and we've answered those very specifically. You know, inmate so-and-so, you have a right to worship, and we can do this, but we can't allow you that particular object because it's a security risk. So we're going to work with your spiritual leader and see what else we can find for you to use that. It's all documented, perfectly laid out. And you know what's happened? We've answered every question, and so far, he's been there for a while. So far, he hasn't sued us. Every question that's come up, we've answered it, and he's moved on. So the grievance process can be very good. Don't leave a grievance unanswered. Look on page 87. They do not, you know, the courts will say that they don't have a constitutional right to a grievance process. However, they do have, you know, it's just a matter of jail management not to respond to them. Because what if you have, Tom mentioned deliberate indifference, if you have a grievance that specifies an issue that's a problem that you know, I'm at risk because, and you do nothing about it, then you've got a potential deliberate indifference issue there. So use that grievance process to your advantage and make sure that you have people that are looking at those. Don't just, you know, look at them and you know, put them away out of hand. Use the process to your advantage, and we can help you. If you've got a kiosk, make sure if they say I'm not getting toilet paper, or officer so-and-so is, you know, spitting in my cell every night, you say put it on the kiosk and document it. Okay? Questions about grievances or due process? Yes.
If a grievance is submitted and it just so happens that same day that inmate gets released from custody, is it advisable they still address that grievance and have it put into their permanent file?
I mean, no, not, I mean, unless it's a sort of an issue that would still apply if they came back. So if they're saying, you know, there's water on the floor and I think I'm gonna slip and fall on it, if they've been released, then you just put released in the response, because, you know, it won't be there when they come back, so.